Hey, good morning, everybody. Ernesto Vega, broker here at Canvas Real Estate. Thank you to everybody that has already joined our audience in this beautiful, beautiful South Florida Friday. Our co-host today is Kathleen from Old Republic. And the reason I back Kathleen is because across my desk with all this volume of files that we're seeing, every other seller is a foreigner. Every other seller is a foreigner. And when you're dealing with a foreigner, it's a little bit different than when you're dealing with a local. And a lot of you have questions, and I'm not an accountant. I don't pretend to be an accountant. I'm not an attorney either. So I said, well, let me reach out to an expert that can join us and share information on what FIRPTA is, how FIRPTA affects our real estate transaction, and how to do them right. So let's give a virtual warm applause to Kathleen. Kathleen, good morning. The microphone is all
Good morning.
yours.
Thank you. Good morning, everyone. I'm Kathy Braid from Old Republic Title, and I am not an attorney nor am I an accountant as well. However, we do have a presentation to go over important facts, important items that you should know when you go on your listing appointment and when working with a buyer. These are taken directly from the IRS website. You can go there for further information. And it's always good to know about it. Of course, unless you're an accountant or an attorney, you can't know everything about it, right? So we just give you some information. Again, it's for informational purposes only. I have been with Old Republic Title for 15 years. I've been in the title business for 30. I started when I was 3. So you know that I'm only 33. And we're going to, as I say, go over this. I've done many different functions within the title agencies and for underwriters. So now I do training for realtors, title agents, attorneys. So without further ado, I'm going to share my screen and we will begin. Okay, so here we go. Okay, I'm going to move this over. I don't want it there. I want it in front of me. So let me do that again. Share screen. Now I guess I'll share screen too.
We're getting a good audience. I think everybody, we say FIRPTA and everybody's ears goes up in South Florida. And I feel that international buyers are not going to stop coming now more than ever. So we
Correct.
need to maybe set up the transaction the right way from the beginning. So
from the beginning, that's what we're going to talk about from the beginning. Okay, so FIRPTA and what you need to know. That's our presentation. And you can see my screen, correct?
Yes.
Okay. First of all, what is FIRPTA? FIRPTA stands for the Foreign Investment in Real Property Tax Act of 1980. Okay, this took effect in 1980, and we're using it more and more now because, as we discussed, the foreign sellers, a lot of the transactions now are foreign sellers and foreign buyers. So we have to be concerned with both. This is actually a withholding, not a tax. So it's called a tax act, but it's actually a withholding, meaning the money has to be withheld at closing from the seller and sent into the IRS. Once the seller files their tax return the following year, or the same year, it would be the following year. Once they file their tax return, that withholding will be applied, and maybe they get it all back, maybe they owe money. It just depends on their financial status. Depends on the treaties that the United States has with those companies, with those countries as far as taxes are concerned. So again, it's a complicated process. It's always best to take care of it at your listing appointment. And I'm going to say that at almost every slide so that you understand it's important from the beginning. You can't talk about FIRPTA at the closing table, it's too late. So it has to happen from the beginning.
Every time I see it come up at a closing table, it blows up. It ends up a phone call to me, and what do we do now? And I'm like, well, breathe, and breathe.
Right. And it's not necessary. It can be resolved very, very quickly at the beginning on your listing appointment. FIRPTA is designed to ensure that the foreign owners of U.S. property pay their share of taxes on the profits, which is the gain when they sell. It requires the withholding and remitting of 15% of the amount realized, which is the sale price, not the proceeds. So if someone is selling a property for $500,000, it's 15% of $500,000. That's scary. If the person,
that's a big number. That's $75,000. A big number.
That's right. So when you go to a listing appointment, you're going to ask the person, are you a U.S. citizen? One of your first questions, you're going to confirm their names. Hopefully you've printed out a copy of the warranty deed. You've printed out the property appraiser's report so that you know that you have the right legal description. Your deed is going to tell you if you're meeting with the correct people, right? So you know who you're meeting with. And then you're going to say, are you a U.S. citizen? And I understand it's a difficult time now with immigration and citizenship, and it's, it's terrible situation that we're in. However, just let them know that you're trying to protect them, to let them know from the beginning, when you're on your listing appointment, that they need to seek the advice of a tax professional immediately, because the tax professional can fill out papers where maybe they don't have to have any withholding, or maybe they can get a reduced amount of withholding, but the title agent can't do that and the seller can't do it. A tax professional has to do it. So you're going to ask that question at your listing appointment, and then you're going to advise them to seek the advice of a tax professional. So again, it requires the withholding and remitting of 15% of the amount, the sale price, which is the amount realized by the foreign person selling U.S. real property, unless there are certain exemptions. And we're going to go over a few of those as we go on in the process. So our next slide will be what definitions are, because you're going to hear me use these words interchangeably. As I said, the amount realized is the gross sale price. An ITIN is an individual tax identification number, and that is issued to a person who is not eligible for a Social Security number. So a foreign seller has to have a tax identification number because they need that for when they file their taxes. If they don't have that tax identification number, there's really no way for the IRS to track the funds. And I remember like in the early 1990s, we didn't have as many foreign sellers here in Florida, well, in Palm Beach County. And people weren't required to have a Social Security number. They weren't required to have any kind of they weren't required to have a tax identification number. As a matter of fact, there were not even any assigned, I don't think, at that time. After 9/11, there was a big rush and a big push that, hey, we have to try to identify people to see if people are laundering money, maybe terrorist organizations, whatever. And they needed a way to track the monies that were coming in because people wanted to know where the refund was. And there was no way to track it, right? So now it's much easier for the seller to get that withholding back. That's why they need to have that tax identification number, or ITIN. A resident alien is a person who holds a resident alien card or a green card. A substantial presence test is something that an accountant can meet with the sellers, speak with the sellers, talk with them, and determine if they meet certain criteria. They have to be in the United States a certain number of days over the past 3 years. They have to be in the United States in the year that they're going to be selling the property for at least 31 days. So let's say in 2021, they were selling a property. They would have to wait until after the end of January, because again, they would have to be here 31 days to meet this substantial presence test, and a number of days for the previous 2 years, totaling 180 days. Again, it's a complicated process. An accountant has to do that, or a tax attorney, and that has to be given to the title agent. Proof of that has to be given. It just can't be a letter saying, excuse my dog, she doesn't know how to behave, so she will be barking through the presentation. So sorry about that. So the title agent can't just take a letter from anybody or from the seller saying, yeah, I meet this. It has to be something that's formal, and it has to be something that the title agent can confirm. That's why it must be a tax professional. A non-resident alien or a foreign national is an individual who is a citizen of another country other than the United States, right? So that would be a non-resident alien or a foreign national. The transferee is the buyer and the transferor is the seller. So if you do go to the IRS website, you'll be seeing these words. So it's just giving you a heads up as to what they mean. Our next slide is foreign person. The IRS definition of a foreign person is a non-resident alien individual, a foreign corporation that has not made an election under the Internal Revenue Code to be treated as a domestic corporation, a foreign partnership, a foreign trust, or a foreign estate. Again, ask the seller to seek the advice of a tax professional at the listing appointment, because if they are a foreign partnership or if they're a foreign corporation, the tax ramifications may be more if they're not paying taxes. Now, people often ask now, well, what about an LLC? People have their property in an LLC. Does FIRPTA still apply? Yes. If it's a single member LLC and that member is a foreign person, FIRPTA applies. So sometimes people will call and say, oh, my customer wants to put their property, they want to do a quitclaim deed from them into an LLC. Well, first of all, that's fraud because they're trying to avoid paying the withholding. And second of all, they're still going to be responsible because it's a single member LLC and that person is a foreign person. So anytime you have that, they're going to have to seek the advice of a tax professional because, again, there may be some way that they can get apply for a reduced amount, or maybe they don't have to pay. So again, always go to a tax professional. Don't assume. It's better to do it right then and there when you're at your listing appointment to determine these things so that it doesn't drag on and you're depending on the title agent to take care of it. The title agent does not represent either party. The title agent represents the underwriter. And a lot of people misconstrue that. So the underwriter, right, as I say, they represent the underwriter. Like an Allstate agent represents Allstate Insurance. An Old Republic title agent is an agent and represents Old Republic Title. So they're not representing the buyer or the seller. They don't negotiate.
So I'm gonna jump in for everybody listening. So we do have a great accounting firm that we here at Canvas use for all of our FIRPTA situations. We do always advise at the moment of the listing is the moment to set up a meeting and have the seller understand. And maybe if there's no tax, maybe if there's no TIN number, maybe we're gonna go for a TIN number, or maybe we're gonna extend the listing a little longer. Maybe we're gonna get if we get an offer, we're gonna extend the closing a little longer. But there are steps to prevent the headache at the closing table. But we all need to be educated enough to know that. So at the end on the Facebook group, I will share the contact info of our tax expert who has been helping us for the past few years and has done a phenomenal job. And in some, there have been no withholding because there's been no gain. And in some, the withholding has been 10% of the original 15% retained, which is a reasonable number, and it's because of the treaties, the tax treaties that exist between the U.S. and other countries. So there are solutions. We just gotta ask the question at the beginning so we can set up the file properly. So then it's not on a Friday at 4 o'clock when you sit to close, is the moment that the seller sees that 15% of his money is going out the other way.
Right, because it's a lot of money. Let's face it, it's a lot of money. Even, like I say, 10% of $700,000 is better than 15% of $700,000, right? So
Yes,
again, certain items that it's very, very important to get it taken care of as soon as you go on the listing appointment. They need to seek the advice of a tax professional, as I said. And I think I probably know who you're talking about. If they need an ITIN, they can take care of that. If they need to do the withholding certificate for a reduced amount that we're going to talk about, they can take care of that. it's, again, best to get your professional involved as soon as possible. It's well worth the money that the seller will be spending because they will be saving the seller thousands of dollars. So if you have to pay, I don't know how much it is. For example, let's say the seller would have to pay them $500 and they save them 15 or 16,000, it's well worth the 500.
Oh yes, it's well worth it all the time.
$500.
It's well worth
Well
it
worth
all the
it.
time.
And that's the way that you would have to explain that to them. You know, would you rather spend $500 here or 15,000 that gets sent to the IRS? Let's face it, I don't like to send money to the IRS. I don't, because you know, you never get it back. They take it out of my paycheck, but I mean, you never get it back, and they always want more. But that's the way it is. So it's always good to do that in the beginning. The withholding agent, most people think that it's the title agent because the title agent gets all the money, right? So we figure, well, the title agent, and the word agent is there, so you figure it's the title agent. Well, generally, the person who pays an amount to the foreign person, the title agent isn't paying that amount. The title agent is giving them a check, but the buyer is the one who's bringing the money to the table. So the person who pays the amount to the foreign person is subject to the withholding and must do that FIRPTA withholding. For real property purposes, the IRS considers the buyer purchasing from the foreign person the withholding agent. A withholding agent is personally liable for the full amount of FIRPTA withholding tax required, plus penalties and interest if the money is not collected and sent to the IRS. Funds must be sent within 20 days of the closing. What does that mean? That means that if in fact money was supposed to be collected and not sent in, the IRS can put a federal tax lien on that property. The tax lien does not attach to the person who sold the property, it attaches to the property. We have had people in this situation. As an underwriter, we get claims, just like State Farm would get a claim for an automobile accident, right? So a person will call up and say, hey, I bought this property and now there's a federal tax lien on my property. I don't owe the IRS any money. Well, guess what? The seller may have. So again, very important to protect your buyer as well, right? And the contract addresses these things. We're going to go over the paragraphs in the contract as well that address these issues. So it's very, very important for you to make sure that you know if the seller is a foreign person, to protect your buyer, because it's the buyer's responsibility. The title agent takes in the money, disperses the money, and as far as the FIRPTA goes, they do it on behalf of the buyer. They send the paperwork in on behalf of the buyer to make sure that it gets there, because the title agent doesn't want that nightmare either, right? Excuse me. As I said, we're going to talk about the contract. So on your FAR contract, the as-is and the regular, paragraph 10I says, Foreign Investment in Real Property Tax Act. Seller shall inform buyer in writing if the seller is a foreign person, as identified by the Foreign Investment in Real Property Tax Act. Buyer and seller shall comply with FIRPTA, which may require the seller to provide additional cash at closing. Well, you can point that out to your seller, okay? The contract addresses it. Are you a foreign person? We have to know this, right? Because it's going to be addressed and you may have to bring additional cash to closing. So that's another way to, if they're uncomfortable answering the question, you can bring a copy of
Catherine, that's a great way to have that conversation as you're getting a listing.
Right.
Just by saying to the possible listing person, hey, we're going to list a property, I'm going to have it sold. However, by law, the contract states that we have to disclose it, otherwise we're breaching the contract from the start. So then from the start, we need to know if you're a foreigner. So,
Right.
It takes the pressure of you being nosy or wanting to know. It's just, you hire me to sell the property, I'm going to sell this property. However, we're going to breach the contract from the start if we don't disclose if you're a foreigner. So I need to know before I get your property under contract while we just get it listed, you need to disclose if you're a foreigner. That's if you're
Right.
prospecting a complete, stranger, if you never had any conversation with them before.
And it is. It's not, as you say, being nosy. It's because the contract says you have to do it,
Yeah.
right? The seller is supposed to notify the buyer in writing. So how often is that done? Probably not very often. Okay, here's another paragraph. The last paragraph of the contract, paragraph V, FIRPTA withholding. If the seller of U.S. real property is a foreign person, the IRS Code FIRPTA Act requires the buyer of real property, to withhold up to 15% of the amount realized, which is the sale price, by the seller on the transfer, and remit the withheld amount to the IRS unless an exemption to the required withholding applies or the seller has obtained a withholding certificate from the IRS authorizing a reduced amount of withholding. Number one, under this paragraph, no selling is required if the seller is not a foreign person. The seller can provide proof of non-foreign status to the buyer by delivery of written certification signed under penalties of perjury, stating that the signer is not a foreign person and obtaining the seller's name, U.S. taxpayer identification number, home address, etc. If the person is not a foreign person, the title agent provides a non-foreign affidavit, and that's in the file. So if the person has a U.S. citizen, if the seller is a U.S. citizen or sellers are U.S. citizens, they sign an affidavit saying this is my social security number, I'm a U.S. citizen, it's fine, okay? So that part is taken care of. The next paragraph, number 2 of paragraph V, which is the last paragraph in your contract, right? If the seller is a foreign person and has received a withholding certificate from the IRS, which provides for a reduced or eliminated withholding in this transaction and provides the same to the buyer by closing, then the buyer shall withhold the reduced sum if required, if any, and timely remit the funds to the IRS. So again, the tax professional will prepare the form. We're gonna talk about the form a little bit more. It's an 8288B withholding certificate, and they send that to the IRS prior to closing, right? If the seller brings a withholding certificate to the closing that has been approved by the IRS, usually they send a letter stating that it's approved, the IRS does, or they send that form back stamped approved, indicating that a reduced amount of withholding or no required withholding, the buyer can rely on that and follow the instructions on the IRS approved withholding certificate or letter. So again, maybe instead of having to collect 15,000, they collect 0, or they only collect 3. But if this is not back by closing, it usually takes they say it takes the IRS 90 days to do it. I don't know. I've heard some of these companies can get it done quicker because they know what to do. They have contacts with people, local IRS, to get it approved. So isn't that a wonderful way to also sell to your seller? Look, you can go to this company and they can help you fill out this form. Maybe instead of collecting $50,000 or $60,000, we collect 0 or we collect 3. So that's a wonderful thing, right? So again, the contract says if they have that withholding certificate and it is approved, the buyer can rely on that to collect the reduced amount or none, right? But it has to be approved by the IRS. It can't just be the form that the accountant sent in.
And you will look as a hero to that seller, and it's going to refer your business, because if it was a $700,000 sale and he's looking at a $90,000 withholding, he's thinking, oh my God, I'm going to lose $100,000 on this sale. And because of your advice and your recommendation, all of a sudden the letter is received and the withholding is only $8,000 or $9,000. At closing, he's going to turn to you and says, you just saved me $100,000. You just so you'll look like a hero. So do the right steps, be the hero, and not be the part of the nightmare at the end.
Right. Okay, and then the last part of this paragraph is, oh, well, let's talk about the withholding certificate. The 8288B withholding certificate, the seller uses this form to apply for a reduced amount of withholding. The tax professional will prepare the document and send it to the IRS to reduce the FIRPTA withholding tax or eliminate it. The form is used to establish the actual tax that should be collected based on the gross proceeds and any other taxes that may be due. Proof must be presented at closing that this was filed, right? Now, if it is not back approved, now the seller comes in and says, well, you know, I have this withholding certificate here that I sent to the IRS, and it says that I only owe $3,000, not the $15,000 that you're collecting. Well, it's not approved yet. So what that means is the title agent will collect all of the $15,000 and hold it in escrow until that money until that form comes back. But the contract also addresses this, okay? If the buyer wants to escrow the funds, the entire withholding amount must be collected until the IRS has approved the withholding certificate, indicating how much, if any, taxes are due. Now you say, why is that up to the buyer? Well, again, item number 3 in paragraph B says, if prior to the closing, the seller has submitted a completed application to the IRS for a withholding certificate and has provided the buyer a copy of that, but no withholding certificate has been received as of closing, the buyer at closing shall withhold the applied percentage of the amount realized by the seller on the transfer. And at buyer's option, they can either withhold the funds, and usually if the title agent, most title agents don't like to hold any escrows.
I noticed that.
Okay. What happens if the IRS rejects that and the seller owes another $2,000? They owe money instead of getting money back. What if it's rejected several times? The title agents have to submit bank reconciliations to their underwriters every month. The underwriter needs to know where all the money goes. They need to see the reconciliation. So they need to see checks in and out, deposits, withdrawals, all of that stuff. And they need to see escrowed funds. Underwriters don't like to have money escrowed because, again, suppose the title agent has the money escrowed and the seller has received that certificate back, that withholding certificate back, that says that they only owe $3,000, but they never get it to the title agent. So now penalties and interest accrue from the time that is released until the time the IRS gets the payment. What if the title agent can't get a hold of the seller or the accountant? There are so many what ifs. Nobody wants the buyer to have a lien placed on their property. So the contract now says that it's up to the buyer if the buyer wants to have that money put in escrow. Because don't forget, if there's a problem, if the money is not sent in, the buyer is going to have an IRS tax lien on their property. Okay, so it's up to the buyer. Or the buyer can say this: I don't care, Mr. Seller, I appreciate that you sent in that withholding certificate, but I want the money sent to the IRS today. I don't want to be dealing with the IRS after closing for something that can attach because of you. Of course, they're not going to say it like that, right? But they do have the option to say, I want to send the funds in immediately, or to have the money put into escrow. If the agent does put it in an escrow, they usually have a time limit on it. And when that time limit happens, if they don't have what they need, the funds are going to be released to the IRS anyway. So most of the time, the title agent will remit it the same day as closing. This way, it really relieves everybody, because your seller is going to be calling you every day. Why didn't I get my money back? Why didn't I get my money back? Where's my money? They're going to be calling the title agent. Really, I've seen it. It's a mess. It's a mess. If any of you have ever been involved in a FIRPTA transaction that has gone bad, it's horrible. And people will remember your name, not as a hero, but as a bad guy who didn't do your job properly. So again,
and that means no referrals, no referral business.
that's right. It means no referrals. They're going to get one of those planes with the sign and have your name on it and say not to use it. You know, that flies along the beach. You know, they're going to advertise, don't use this person. But with all kidding aside, this is really important stuff. So it's important for you to do your part to protect both the buyer and the seller and yourself, right? And yourself and your reputation. So again, if that withholding certificate has been sent into the IRS and they bring a copy of it, the buyer has a copy of it, but it's not approved as of closing, the entire amount is withheld. So now the entire amount is withheld and the buyer says, well, I want to send it in today. Of course, the title agent is going to send it in with a copy of that withholding certificate so that they know that the withholding certificate has been sent in. They can see it, right? They have to have a tax identification number so that they can track it, so that maybe they'll process everything at the same time, all right? But again, this is all stuff that needs to be done prior to the closing table, right? So where do we start? At our listing appointment. Most important thing. And listing appointment and tax professional. Whenever you hear FIRPTA, listing appointment, tax professional. And those are the two most important things you can do for your client and for yourself and for everybody else involved. So as per the contract, the buyer has the say as to when the money is remitted if a withholding certificate has been sent to the IRS, but no approval is available at the time of closing. Okay, now we're going to talk about the wonderful buyer's affidavit and certification that everybody seems to love, okay? Okay, there are certain requirements for the buyer's affidavit. It's for residential transactions only. The buyer must be an individual. Vacant land is excluded even if the buyer intends to build a residence on the property. Buyer's refusal to sign the affidavit results in 15% of the sale price being collected and sent to the IRS. The seller.
Can we pause there? Because I had a couple of questions that somebody asked. And that is like the number one question. Can a buyer refuse to accept an affidavit withholding?
Absolutely.
Okay, everybody heard that? Because I get that asked a lot. Ernesto, I have a listing and the buyer does not want to sign it. How can I force them to? You can think of it and incentivize them with, maybe lower price or something. But if the seller wants to sell and this is the only offer he has, and that buyer is not interested, he can just say no, and the whole 15% is send up straight to the IRS, right?
Yep.
All right.
That's the bottom line. It is not a requirement. The buyer does not have to sign it. It's an option. And it has to be a resident, it has to be an individual, right? The buyer's refusal to sign results in 15% of the sale price collected and sent to the IRS. The seller is still responsible for filing a tax return and paying the full amount of tax due the next year, right? So now, this is so important. Instead of everybody worrying about the buyer or trying to force the buyer to sign the affidavit, ask the seller to see a tax professional at the listing appointment. It resolves the whole issue, because you may lose a sale because the buyer doesn't want to sign it. Whereas if the seller went to see a tax professional, maybe they didn't have to pay any tax anyway, and you would still get the sale and you're a hero and nobody's aggravated, right?
I think that's the key. That's the key. You keep repeating it, and I'm glad that I'm not the only one that keeps thumping that drum. At the beginning, deal with it at the beginning, and you will have a happy transaction and a very, very happy seller.
Yeah.
Because he's heard from everybody, the IRS is gonna steal your money if you introduce them to the right person, and they're not taking. Like I said, in some cases I've seen it with a zero, just zero.
It's
And
zero
yeah,
sometimes, but they have to do it because the seller is not going to feel comfortable until they talk to the tax professional. All right. Especially if the price is 300,000 or less, because they're thinking, oh, the buyer has to sign that affidavit, so I'm not going to have to pay any. That's not true. It's an option. You cannot force the buyer to sign the affidavit, period. It's not a requirement. Okay, so our next slide is, this is another thing where you have to be concerned with the buyer. The affidavit is signed based, and when they first started with this affidavit, I was doing a presentation in a realtor's office. And when I said this, the managing broker screamed at me and told me to leave his office because I was asking him to have his realtors ask their buyers to commit fraud. I didn't make this up. This is not my rule. This is the IRS, what they say. It's the buyer's intent. So the affidavit is signed based on the buyer's intent at the time of closing. They don't have to write down what their intent is. We usually told them, oh, you have to stay there 6 months and 1 day. That's what it used to be until this form came out. Well, now they have this form. So this is the buyer's intent. So the IRS also says, should a claim for taxes not being paid arise regarding the residency requirement, the buyer would have to show that a change in circumstances not contemplated at the time of closing prevented the buyer from complying with the signed affidavit. Let's look at what the language is in the affidavit. All right. So this is the what happens if the buyer does not fulfill the residency requirement. Well, this is taken right from the IRS's website. For example, if a buyer of U.S. real property fails to withhold from the amount realized in reliance upon the exemption that the buyer planned on using that property as a personal residence for the next 2 years, but did not in fact reside at that property for the minimum time required, the buyer shall be liable for the failure to withhold if the seller was a foreign person and did not pay the full U.S. tax due on any gain recognized on the transfer. However, if the buyer establishes that the failure to reside the minimum number of days was caused by a change in circumstances that could not reasonably have been anticipated at the time, the buyer shall not be liable. Well, what does that mean? Okay, there's a lot of words there. It means that, let's say I'm going to send my child to school in Tallahassee, for example. They're going to go to college in Tallahassee. So instead of having to pay rent at an apartment or to pay for a dormitory, we decide, well, we're going to buy a condominium because the condominiums are less expensive, and then eventually we'll be able to rent it out and all this other stuff. So our son goes to school, or our daughter goes to school, and they're there for their first semester, and we purchased it for $295,000. They're there for the first semester. They're there for the second semester. So they complete their first year. They've been there the required amount of time, and then they decide they don't want to go to school there anymore. Okay. So I decide that maybe I want to rent it, right? Or something like that, or I want to sell it, or I want to do this or that. Well, could I have foreseen that? Could I have known that my child wasn't going to like going to school in Tallahassee? Can I prove that there was a change? Yes, I can, because now they don't go to school there anymore. But I didn't really know if they were going to like it or not. So that's not something that I could have seen. The IRS had another example of someone that was transferred because their company was growing. So they were transferred, they purchased from a foreign person, they signed the affidavit, the monies weren't collected, and 18 months later, they got transferred. Okay. So the IRS contacted them and said, you know, you signed this affidavit and all this other stuff. well, the person said, well, I didn't know I was going to get transferred again. And they said, well, couldn't you have anticipated it because your company was growing? Do you think that maybe they would have transferred you again? I mean, to me, that seems really far-fetched. But again, it's the government. You know, I grew up in the 70s. I don't trust the government. So I don't know how to know, but they know, right? So they know these things, and it's not worth the risk for the buyer to possibly have that on their property, a lien on their property. So again, the IRS says that if you have a change of circumstances and you kind of thought it might happen, well, then maybe you'll be liable to pay the taxes. So this is the language in that affidavit. The buyer is acquiring the U.S. real property described in paragraph 1 from the seller for a purchase price of not more than $300,000. The above described property is being acquired for use as the affiance residence or for use by affiance family members at least 50% of the number of days the property is in use during each of the first 2 12-month periods following the date of purchase. Therefore, the undersigned hereby directs whatever title agency not to withhold the withholding amount. The buyer's refusal to sign triggers 15% of the sale price to be collected and sent to the IRS. So again, so it's affiance or affiance family members. So for me, it could be my brother, it could be my cousin, it could be my children, it could be my husband's brother, his children, family member, okay, for the number of days the property is in use. Now, people ask me, can they rent the property? I don't know. That's an accountant question. So if someone is purchasing it and wants to rent it, well, that is not going to work if they sign this. If they're going to use it for a certain number of days and rent it for a certain number of days, I don't know the answer to that. That's something that the tax professional has to answer, because if the buyer is interested in buying and the seller's a foreign person and the seller has already contacted an accountant, maybe this doesn't even have to apply because maybe they don't have to pay any taxes and you don't have to deal with this affidavit. The buyer doesn't have to worry about getting a tax lien put on their property, and you're a hero. Seek the advice of a tax professional. The seller has to seek the advice of a tax professional. It's really all on the seller. It shouldn't be on the buyer. It should be on the seller, because the seller is the one who's going to have the money taken away from, you know, from their.
So one big takeaway to everybody listening to us live, and everybody's going to watch this later, watch us at any other point in time. The big takeaway here, the myth is the property's under $300,000, there's no withholding. The property's under $300,000, there's no withholding. And my answer is always yes, as long as the buyer signs the FIRPTA affidavit. If the buyer does not want to sign, the withholding still kicks in, right?
Yes.
Right. So everybody's like, well, it's under $300,000, I don't have to worry about FIRPTA. No, if you have a buyer that is willing to cooperate. If a buyer is not willing to cooperate, their withholding will still take place.
Now, here's another thing. If you're working with the buyer needs to protect themselves as well. You're not only worried about the seller not having to collect the money. What about the buyer? What if this fails? Okay, for some reason, this clause fails, the IRS finds out. Now the IRS is going to put a lien on that property. And what is the buyer going to say to you? Because you said, oh yeah, just sign the affidavit. What are they going to say to you? You told me to sign the affidavit, and now I have a lien on my property from the IRS. Who's going to pay it? You? Because you advised me. You said, just sign the affidavit. You don't have to worry about it. Yeah, they do. Yeah, they do have to worry.
They do.
They really do. So both buyer and seller need to be protected. That's why get a tax professional involved. Maybe even have the buyer, if they can, contact the company that you use. Let them talk to the buyer. Let them talk to the company that you use. Maybe they can advise them and they can explain. Maybe they can rent it. I don't know. I'm not an accountant. So maybe there is a way that they can buy it. They can sign the affidavit. Maybe. I don't know. always seek the advice of an accountant, even if you're working with the buyer. Okay, because you want to protect your buyer, because you know what? Your buyer wants you to be a hero too. Because if your buyer has a tax lien placed on their property because you talked them into signing this affidavit, you're not going to be a hero, you're going to be a bad guy.
Yep.
And they're going to tell everybody, don't use them. Just like with the listing agent, you know? So again, your job is to keep your reputation, make money, because that's what you're in the business for, but to do it right.
And to earn referrals. So Catherine, I have a couple of questions.
Okay.
If a corporation is registered in, let's say, in Delaware, not in Florida, um, does it's the same thing. It doesn't matter, right? As long as it's a U.S. corporation, it has to have Social Security members,
It has to
more
have
than one
tax
member.
ID number. It has to prove that they pay taxes. Again, they, if they pay taxes, it should be okay, I assume. I hate to say anything because I really don't know, but I would say if they have a tax ID number, they should be paying taxes, I would assume. So I don't know what the title agent is going to require. So again, that may be something, maybe some of these more technical questions are something that you can have the company that you deal with do a little presentation to answer about corporations, to answer about the trusts and things like that. I know of one, they're on the West Coast and they do presentations for realtors.
Yeah.
So,
No, we have a local one that what I'm
okay.
going to do, because
Yeah.
this is such a hot topic. I'm going to bring back the attorney and the accountant, and I
Yeah.
might do like a panel just open to questions, because I think that might flow. If they assign it to a corporation, the foreign national assigns it to a corporation, that does not solve any issue, right?
Again, I don't know. That's a technical question. That's a legal and an accountant question. And that's
Robin, I'm gonna reach out to the attorney, Robin, and I'm gonna get you those answers. I'm
yeah.
gonna get you those answers. I have one more question. Hold on. So Adriana's asking what you were explaining. Adriana, I will send you if you have that. She's asking, can it be purchased and rent, seasonally and lived on it? I seen it done. I seen the cases with that accounting firm that we use. I seen it where investments have been made where our short-term rentals are being used, but it has been a scenario that they have sat down with the accountant and they have understand the implications. So Adriana, I will send you the contact info of the accounting firm that we use, because yes, it could be done. It just has to be done the right way. So we'll move right along, Kathleen.
Okay. Yep. And I'm sorry I can't answer those questions, but I really don't want to give anybody incorrect information.
Got it.
Yeah, this is just for informational purposes only. Okay. How is it determined whether the buyer meets the residency requirement? And again, this is from the IRS. For example, if a buyer purchases in her name only a U.S. real property for $299,000 and states that she is going to reside in the property, right? She's filling out the affidavit. The buyer is not married but has an adult daughter. The property is purchased on January 1st, 2017. The buyer and her daughter live in the property together through the end of April 2017. On May 1st, the buyer takes a temporary position overseas where she lives for 8 months while her adult daughter lives in the property. The buyer returns on January 1st, 2018 and lives in the property with her daughter until May 31st of 2018, when the buyer takes another temporary overseas job until February 22nd, 2019. So now the buyer is the one leaving. The adult daughter is residing in the property, okay? Although the buyer only resided at the property for approximately 33% of the days during 2017 and 42% of the days during 2018, Her daughter resided there 100% of the days during 2017 and 18. Therefore, the property is considered a residence of the buyer, even though she wasn't there for those 2 years. So again, there's a way to do it. I just don't know how to calculate it. So that's why it's so important to talk to a tax professional. It can be done, I guess.
Yes, that's the main thing. Yes, it can be done. Yes,
Yeah.
it can be done. You just got to sit down with a tax professional, have the conversation from the beginning, and everybody understand the way that it has to be done.
Yeah. In this case, they didn't rent it. The daughter lived there. So I'm not sure about rentals. And again, a tax professional can answer that for you. Okay. If it's greater than 300,000 to $1 million, and the affiant of the U.S., the affiant is buying the property for more than 300,000, but not more than $1 million, the above described property is being acquired as for use as affiant's residence. Okay. Therefore, the undersigned directs the agent to, or the buyer to collect only 10%. Again, affiant's residence would mean they have to live there, right? So if there's any question as to that, again, that's a question for an accountant. Buyer's refusal to sign triggers 15%. 15% of $1 million is a lot of money. They need to go to a tax professional, especially on these big transactions. Listing appointment, always, always, always seek the advice of a tax professional.
And one tip, one advice is if you'd have listing appointments don't happen by surprise. You're not walking down the street and you walk into a listing appointment. So
Right.
if you have a listing appointment on Wednesday for a $1 million house in Miramar, you may want to preempt your accountant person that we use and the attorney and say, hey, I'm going to be having an appointment in such and such time. A question or two might come up. Can you have in your calendar an open moment that if I call you is for a question? And I've seen both attorneys and the accountant that we work with accommodate those situations where they're expecting a call from you. Then listen, they're not gonna do a whole that solve the problem, but they can answer a couple of questions, introduce themselves, and they will more than likely end up saying, let's schedule an in-person visit so we can get your case straightened out the right way. But it puts you at another level. If you are a listing presentation and in the middle of the presentation, when the issue comes up, you can dial up the accountant on the phone and he can answer some basic questions. That puts you at another level that no matter what other agent is coming in the listing presentation after, they're going to say, you know what? Ernesto is not only the real estate person I know, he has the entire team around them that it's going to help me navigate this transaction. So in a competitive market like the one that we are now, you need to have the entire team and present that image that it's not like, well, I got to get back to you. Well, I got to get back to you. Don't be like everybody else. You know, go walk in there, prepare so you can walk in confident. So
yeah, and that's great. That's great advice. That's a great tip. I like that. I might use that. I'm gonna steal it from you when I'm doing this. Not really, I wouldn't do that. Okay, so anything over $1 million, again, 15% has to be collected and sent in unless, of course, they've gone to the accountant. So exemptions from withholding, the seller signs a non-foreign affidavit that the title agent is going to prepare. The purchase price and intended use of the property qualify the transaction as exempt, and the buyer agrees to sign that affidavit. The foreign seller provides written proof from a tax professional that no withholding is required. The foreign seller presents a withholding certificate approved by the IRS by the closing date indicating no withholding. FIRPTA forms, the 8288 is the form that's sent to the IRS along with the withholding check. So it's completed and sent to the IRS along with the check and any necessary documentation within 20 days of the closing. The buyer is the withholding agent, and the information on the form must be in the name of the buyer and seller, not the title agent. because the buyer was the withholding agent, not the title agent. So the buyer has to know that they're going to be signing these papers. And sometimes the buyers are a little reluctant because they don't want to be involved with the IRS. They're sent on behalf of the buyer by the title agent to the IRS. Tax ID numbers are required for both the buyer and the seller so they can track it. So now if you have a foreign seller and a foreign buyer buying from a foreign seller, they both need a tax identification number. So you're going to ask your borrower as well, are you a US citizen? Because the IRS requires when you're purchasing from a foreign seller and you're a foreign buyer, you also have to have an ITIN. So the accountant who the seller has used can also prepare the paperwork for the buyer. Now, if they don't have it prior to closing, the tax ID numbers, again, the title agent is going to be sending in the paperwork on behalf of the buyer. So copies of that W-7 form and everything that has to be sent is going to be sent in so that everything can be completed more or less at the same time. It's always better to have it done prior to the closing so that it doesn't hold up anything when the forms are being filled out. And I'm sure the accountant can fill out the forms at the same time if they don't fill them out ahead of time.
Quick question.
Yes.
Let's say foreign seller under $300,000, foreign buyer.
No money's being sent in. If no money is being sent in, then they don't need a tax ID number because
can that foreign seller who's it's gonna, I mean, they're buying, a lot of sellers just buy things in Florida to park cash. Just, a safe place to park $300,000. So can that foreign buyer sign the FIRPTA withholding? So there's no withholding for that seller?
I don't know. That's an accountant question.
Hey, Alvaro, I'll get you. I'm gonna say Alvaro's asking that great question. Alvaro, I'm gonna send you the contact info or our tax expert. My answer, based on the experience that I've seen, is yes. But I will say talk to. I'll send you the contact info. Have a conversation with Jose. But as long as not being bought as an investment, as a rental investment. And that's why the conversation needs to be had. It's if it's under $300,000, I've seen them when they're signed and there has been no withholding. But that's why I love this topic, because the more you talk, it's like an onion. The more you peel it, the more the more it makes you cry.
Right. And I don't know that I'm not. If I was an accountant, I would be glad to answer these questions, but I'm not. So I don't want to give you incorrect information and then you get in trouble, or your buyer or seller gets in trouble. This is just general information. Again, tax professionals should prepare the form on behalf of the buyer and seller. It's just make sure it's done correctly. Frequently asked questions. A husband and wife hold joint title to U.S. real property. The husband is a foreign person. The wife is a U.S. citizen. They are selling U.S. real property for $500,000. How is the amount of withholding determined? If the buyer doesn't meet, if the foreign person doesn't meet any of the like the standard presence test or anything else, then monies would have to be collected. So in the absence of evidence to the contrary, a husband and wife are each deemed to own 50% of the property for purposes of withholding. 15% applies to the foreign person. So on a $500,000 purchase, you divide it by 2, and then the $250,000 is 15% is taken, so $37,500 would be withheld. That's why if they go to a professional, tax professional, maybe nothing has to be withheld. Again, this is something that people ask questions quite frequently about this as well. Who is responsible for the proper remittance to the IRS? Well, we said, again, the IRS considers the buyer the withholding agent. In most cases, the closing agent is the party that sends the check and necessary forms to the IRS on behalf of the buyer, but the buyer is held responsible for seeing that it's done. And again, the IRS can place a lien on the buyer's property. Now, I've seen title agents, they don't take it upon themselves to send it in, and they just hand the check to the buyer and say, it's your responsibility to send it in. So make sure that if you're dealing with someone, they know the title agent does it on behalf of the buyer, or if the accountant will do it on behalf of the buyer. Again, it just depends on who you're dealing with. Is there an exemption from 15% withholding when a foreign person is the seller in a short sale? Again, the seller should seek the advice of a tax professional, because maybe there is, maybe there isn't. But the title agent is going to should put that on the short sale HUD or whatever, the net for the seller. Not net, the cost.
So we haven't seen short sales in a while, but I can tell you that back in the day, the IRS wouldn't flinch.
Right.
15% is due, and they don't care.
I don't
want to say it's heartless, but it was heartless. It's my 15%, my $45,000 due. Give me my $45,000.
Right. So the short sale lender has to know that. You can't surprise them.
No.
So that would have to be to be disclosed in the beginning. A foreign seller lists an investment property and would like to participate in a 1031 exchange. Is the sale subject to FIRPTA withholding? Possibly. The seller should contact the title agent, and contact a 1031 and let the title agent know, and they can contact a 1031 exchange company. If it's a like exchange and the seller is not getting any money back, then they wouldn't have to pay any money for FIRPTA. But if they're getting any money back, which is called the boot, and let's say they're selling a property for $400,000 and they're doing a 1031 exchange, but the property that they're exchanging is only $300,000, and then that they're going to figure out what has to happen there. So maybe they have to pay, maybe they don't. Again, these intermediary companies usually know how to do that, how to figure that out, or the accountant.
So to everybody listening, this is key, because I seen the rise of 1031s as a loop around FIRPTA. As being in South Florida, I think we know that there's reputable and unreputable companies everywhere.
Right.
And all it takes is one mistake, not to cost you your license, but to cost you a lot more than your license, from legal defense and criminal. So I have seen more than one case where they have tried to do a 1031 that never finds a like kind property, and after the period expires, they request the money back. Mm-hmm. Without disclosing to the intermediary company that this was part of this is a withholding of kind. Wow. If you come across that situation, please reach out to us if you are on the buyer's side of that transaction, because like Catalina opened with, is the buyer the one that's responsible, which means your buyer that you're representing is the one that's responsible. So although the sellers is trying to do funny business in the back end, and you get a smell of the funny business, you need to disclose that immediately, because at the end, like she said, the one that's going to get a lien on their property is not that seller, is that buyer you represented. And if you knew about it, guess what? You're guilty by association.
Yep. Again, it's all about, again, at the beginning. It all starts at the beginning, just like the Bible. It all starts at the beginning, right? Everything happens at the beginning. Go to your listing appointment, foreign seller, seek the advice of a tax professional. All these things can be taken care of. Even if you know the person's investor and they're going to do a 1031 exchange, they may have an exchange company. They may have an exchange company that you use. Just make sure, if you think something is fishy, then don't move forward, because again, you can go to jail as well and get in trouble. Fine.
Yeah, you're messing. Remember, Al Capone didn't go to jail for anything but messing with the IRS. So
right.
Al Capone only went to jail for messing with the IRS. And so you don't want to mess with the IRS. So you don't want to be accomplice. You don't want to be,
No, you don't. So some tips, again, I'm going to say it again. Verify the citizenship at your listing appointment. U.S. citizen, born or naturalized, or a resident alien, right, at the listing appointment. Possibly include FIRPTA transaction in the MLS. That gives everybody a heads up. Some people don't like that suggestion because they say, well, they're going to limit my people. Well, you're putting it out there already. So you're putting it out there. And you've already advised your seller to see the tax professional. So maybe everything will work out better if everybody knows in the beginning and is not surprised.
So I'm pro that tip, because why do you want to waste time showing a property to a buyer that's not going to buy the property? If you have a listing in Aventura and you live in Palm Beach, and that's a 2-hour drive to Aventura, why are you going to show a property that buyer at the end is not going to purchase?
And if they don't understand,
disclose it up front. Disclose it up front.
Yeah, if they don't understand what FIRPTA is, maybe you can have a talk with them, and maybe you can explain to the seller, this is why you're going to put it in there, because the contract says you're supposed to tell the buyer in writing. Right in the beginning of the contract, not the last paragraph, outlines everything, but it's paragraph 10. So show it to them. You're supposed to let them know. So why should I bring here, as Ernesto said, why should I bring here people here that aren't going to buy it because it's a FIRPTA, because you're a foreign seller. So let me bring somebody that's interested, right? So I think it's a good idea. Suggest the sellers seek tax professional advice at the listing appointment. Foreign seller must have a valid tax identification number, or ITIN. A foreign buyer purchasing from a foreign seller must also have a tax identification number. Now, tax identification numbers have expired. So the way you know it's a tax identification number, it begins with a 9. All ITINs begin with a 9. They're the same format as a social security number because, it goes through computers and they can't recognize anything else except for the format that our social security number's in. So tax ID numbers that were issued in 2013 have expired. A lot of them are expired. So again, if you have a foreign seller and they have a tax identification number, let them contact the accountant or go on the IRS website and you can see which numbers have expired. Okay, so they all begin with a 9 and the middle 2 digits are the ones that expired, like 72, 74, 75, 76, 77, 78, 91, 92, 93. Those are expired. You can see the numbers on the website. If they have one that's not expired and they have not used it in the last 3 years, that may be a problem as well.
Yes.
So if they have that tax ID number, they need to speak with an accountant to make sure.
What she said in a nice way is, if they have not filed taxes in 3 years, yes, they have a tax ID, fantastic, beautiful, but their last tax return was 2016, you're gonna have a problem.
Yep. So again, they need to seek the advice of a tax professional. Discuss the FIRPTA, the paragraphs relating to FIRPTA in the contract, include the FIRPTA addendum, discuss FIRPTA issues with your client, any forms that have to be filled out, the amount of money withheld. If applicable, have the buyer sign the affidavit prior to closing. If they want to, they don't have to, if they want to. My advice, I don't know. I wouldn't talk them into it because I don't want to be responsible if there's a problem. I don't want to be responsible for them coming back and saying, look, you talked me into this and now I'm screwed because now I have an IRS tax lien. Closing table is not the time to discuss FIRPTA. It has to be done at the listing appointment. Now I've included, I'll send this presentation to you, Ernesto, and then you can share it. The information that's quoted from the IRS, this is a website you can go to, and it will explain some of the same things that I did today. They updated it so it's not as confusing as it used to be. They put it in English, not all these big long words and all these big legal descriptions and everything. So it's much easier to understand. So that's it for me today. I answered the questions I could, the ones I couldn't. Again, I'm not an accountant and not a tax professional. This is just, as I said, for informational purposes only.
So out of all the questions, and thank you, Kathleen, because that was a great presentation, and we'll probably be doing a couple of more, in other topics coming up. So there's a lot of questions that you covered them all. There's just one that maybe you covered, but I wanna break it down again. Property is purchased. Okay, mom and dad, right, are foreigners, and bought and are part owners of a house with the son who's here in school at UM. So they bought a property for $380,000 when they purchased it, right? And it's half the kid, half the parents. So they're asking, is the withholding going to be the entire new sales price or just 50% of the value?
50% is husband and wife.
Got it.
Right.
Actually, the wife has a social and files. But yeah, so okay.
Yeah, the accountant would figure that out, because if you're husband and wife, okay, then that's considered 100%, so if 100% ownership for each. But if one is a foreign person, then it would be 50%. It would be
50%.
I believe. Accountant question as well.
Okay. Seller is okay. Seller is I love the Canvas team, because like you guys are so many of you doing so many different type of transactions that you educate the entire team just by the activity that you guys have. So seller is a foreign national seller is an American national living in the Middle East, filing taxes in the US. Does it have to do a withholding? No. If he's a U.S. citizen still filing taxes, I answered. I'm going to let you answer. Sellers a foreign national living in the Middle East, still doing tax returns in the U.S.
That's fine, because you know how I know that? I do remote online notarizations as well.
Okay.
I have closed people all over the world. As long as they're a U.S. citizen, they pay taxes, right? Then it should be fine, because I know I can do my remote notarization. Now, I would say that if I was doing that transaction, if I were the title agent, I would want some type of proof that that person did pay taxes, just besides their social security number, because I have something in your file to corroborate it. But if they pay taxes and have a social security number, they should be good to go.
But again, doesn't matter where they live.
Right. Doesn't matter where they live.
Okay. And the last one, and this one, I think trumps that last question was a woof. And I think this one trumps it. Buyer signs the affidavit, and now buyer is assigning the contract to a different buyer. So the last buyer, it's the one that is going to have to sign a new affidavit, right?
I have no clue. I don't know. I don't know. I have no clue. That's a good question.
Yeah.
That's an accounting question or an attorney question.
Attorney question. Okay, I'll get you. I know who sent me that question. I'm gonna go back to Michelle and Jose on that one and get you an answer. But in my humble opinion, if buyer set it under contract and then that buyer is selling that contract before closing, that new buyer is the one closing, which means he's the one responsible for the tax obligation anyway. So that new buyer has to be aware that the seller is a foreigner and that there's going to be a withholding that is going to be passed down to him. The middle guy, the first buyer is out. I mean, he's out of the photo, out of the picture, per se. Yeah. I tell you, they're gonna ask you good questions. This group.
Yeah, they're good. It's great also that you have an attorney and an accountant that can answer these questions. Not every realtor, does. Not every broker does. So it's great that they do have the legal and the accountant there to assist with that, to make sure that they do it right. So that's great. Okay, Jose, Ernesto, I'll send you this. I'll send you this presentation and then you can share it.
Thank you. Thank you everybody for attending today. It's been a pleasure to share this time with you. This is gonna be stay there on our Facebook private group. We're also gonna load it to our YouTube. And as soon as I get that presentation, I'll share it with all of you. Have a fantastic and productive weekend, and see you guys at the next one. Bye-bye, Kathleen.
Bye-bye.